All right. And employment law, you expect 10 questions. Formation and constitution of organizations, 10 questions. Capital and financing of companies, 10 questions. Management, administration, and regulation of companies, 20 questions. Legal implication related to companies in difficulty or in crisis, 10. Governance and ethical issues relating to business, 10. So under each area, and the mark weighing is making 100%. First, it used to be written. So when it was written, we're expecting essay type questions. But now that is objective test, it means the percentage adds up to 100%, and it's 100 questions you're going to answer. So the if it says 5% for the first topic, automatically means you should expect 5 questions from that area. So that's what you are going to meet. So for the first topic, when you talk of essential elements of legal system, that's where the legal system of Ghana, you introduce the legal system of Ghana. You start with what is the constitution, what are the sources of law. Where we see that sources of law is from the 1992 Constitution, Acts of Parliament, customary law, that's our traditional or local laws, the common law, and any law that was in existence before the 1992 Constitution. To the extent that doesn't contradict the 1992 Constitution, these are sources of law. Then we saw the judicial system, how it moved from the Supreme Court all the way down to our the district level court. For each court, we have the number of justices, we have the number of judges that should be present for court proceedings to take place. They all have their various jurisdictions. The cases that each court can handle. All that falls under the elements of the legal system in Ghana. Remember, it's in Ghana. Then for the second topic, which has to do with legal rules relating to laws of obligations. When we talk of, let me go into the, when we talk of the laws of obligation, the source of law, like I said, under the legal system also, you also have the ADR, that's alternative dispute resolution. That has to do with other conventional ways to settle disputes apart from going to the law court. That's where we have our reconciliation, arbitration, mediation, negotiation, and what have you. Then under the law of obligations, that's where it's talking about legal relationships. It's talking about legal relationships where two people enter an agreement that is legally binding. Therefore, puts placing obligations on them. That's where we have our law of contract. Law of contract is the fundamental issue under this area, because as you proceed to see other forms of legal relationship, you see that the issues in law of contract to come to play. For example, as you go on, you see agency. As you go on, we see some things about companies, who are officers of the company. As you go on, we see some things about contracts when it comes to sale of goods. We will see employment contract. All these things are based on the basis of law of contract. So under law of contract, we have the formation of a contract. How is a contract formed? Then we have the execution of a contract. How is a contract discharged? Then we have breaches and damage, breach and remedies that come as a result of a contract not being adequately or according to the terms and conditions, not being discharged according to the terms and conditions. That's our law of contract. So at the formation stage, we know there's an offer and there should be an acceptance. This offer and acceptance, both parties, that the party that is offering, the party that is accepting, they all have rights and they all have obligations. They are all bringing a consideration, something, they are all putting in something into the contract. They are putting in something into the contract. That's the formation stage. Therefore, the discharge of the duty, we have how contracts are discharged, either by full performance or by partial performance, where one party accepts the partial performance, or by a breach, And where there are breaches too, we have various measures that the court will put in place to redeem the party that is affected or the victim. Then the loss of obligation, we have tort. Tort. Tort has to do with where you have a duty of care. And I thought we'll see something like negligence. And I thought we'll see assault. And I thought we'll see battery. And I thought we'll see trespass. That's where, as individuals in a society, we have a duty of care towards one another. Tort has to do with personal relationships, things that affect personal relationships, or things that affect issues between two individuals. For example, assault. For example, where you commit a battery. We have assault, we have battery. We come to that, we have verbal assault, we have physical assault, we have different forms of assault. So things that have to do with doing the right thing between two individuals is covered under what we call tort. We also have what we call negligence, where the law determines that you owe a duty of care. What do you mean by owe a duty of care? Where you have to do the right thing in a certain situation. In a certain situation, you're in the best position to do the right thing to save your neighbor. In that instance, you owe a duty of care to the individual. Where you breach that duty and the person is affected, we can say negligence have come in. All these things come under the issue of torts. Then, as I earlier on hinted on, we have agents that outline the relationship between agent and a principal. Relationship between the agent and the principal, where the principal is the one in charge, or the principal is being represented by the agent. We have the duties of the principal, we have the duties of the agent, and they all have their rights. They all have their rights. And where there is instances of damages or instance of a loss arising out of one instruction or the other carried out, who bears the loss? Who bears the loss? There are instances where the principal bears the loss. There are instances where the agent bears the loss. That's for agency. Then we have sale of goods, or hire purchase and negotiable instrument. So for sale of goods, we have the laws that even define what a good is. So under the law, we know a good has to do with a tangible, movable item, something that we can see and that can be moved. That's what is defined as a good. That's what is defined as a good. And a good, we have a buyer and we have a seller. We have a buyer and we have a seller. When is a sale made? We say a sale is made when the two parties agree to trade on the item, not necessarily when money is paid or when the item is delivered. Once they agree that they are going once they agree and the one who is offering to sell has the intention of transferring ownership or transferring property of the item to the buyer, we are saying that a sale is made. And the Sale of Goods Act outlines various rules and regulations or various provisions that protect the various parties. So we have provisions that protect the seller, we have provisions that protect the buyer. Both of them have their duties. The seller has to deliver the good. The buyer has to accept and pay for them. The seller has to make sure that the goods are according to what was agreed. And under sale of goods, we have what we call we have instances where the goods are ready. So we have ascertained and unascertained, where the goods are ready and can be seen and delivered. That's ascertained. Then we have unascertained. That's where the goods are agreed on. For example, you go to a seamstress or tailor to sew a dress for you. At that moment, the dress is not material. You can't see it. But then you enter into a contract that you should sew a dress based on so and so qualifications or characteristics. You give the specifications, you take your measurements, you give the design. All those things are given. So once at the moment or at the time that the contract or agreement is being made, the good cannot be visibly seen or identified. In that case, it is unascertained. Or maybe you go into a contract that you are going to sow some crops. When the crops mature, you sell them for so and so much. At the moment where the agreement is being made, the crops are not ready, so it's unascertained. They go through a process to become ascertained. The law says that once it's unascertained, before you enter into that contract, you should have given a description of what the final good will look like. You give a sample for the person to see. And the law says that the seller is to make sure that the goods match the description or match the sample. Then under the obligation, we have the insurance and banking contract. Under insurance is where an individual, before that, we also have negotiable instruments. We also have negotiable instruments, and we have hire purchase. For the hire purchase, it's similar to sale of goods, just that for hire purchase, at the initial stages of the agreement, there is no transfer of ownership. We come to see that there's a difference between transfer of possession and transfer of ownership. You can have possession of the item. That's the one who the owner can give you the item and you can possess it and be using it, but then it's not yours. In that case, you have possession. You don't have ownership. You have possession. You don't have ownership. So the law clearly draws the line between ownership and possession. So in sale of goods, you are transferring ownership at the initial stage. Once the sale of goods agreement is made, ownership is intended to be transferred. But when it comes to hire purchase, at the initial stage, the individual or the buyer has the item and is using it with the intention or with the option to purchase it after payments of installments. So until all those payments of installments are made, the item is not his. The item is not his. When he finished paying for the item before he gets the ownership, so the whole time that he's using and paying for it, it's not yet his. He has possession of it. That's the difference between hire purchase and sale of goods. So on the hire purchase, the one who has hired the item with the intention to later buy it, he has the obligation to make sure that he makes the payments according to the agreement. According to the agreement. Then we have negotiable instruments. Negotiable instruments are instruments that are not money, but then they act like money. A classic example is a check. You can pay for something with a check. You've not given cash or you've not made a transfer of money, but then by giving a check, it serves as an instrument that represents money. We have a promissory note where you write a note. That is a promise to pay. That is a promise to pay. That one too can serve as money because in that instance where you issue that note or that document or that instrument, it is serving as money. That's what I want you to keep in mind when we come to negotiable instruments. There are items or documents or instruments that they are not money, but in the moment they can act as money. And the actual money will come later. But in that moment, they can act as money. So you are holding a check for payment. Yes, you have been fully paid. You have to go to the bank for the money to be cashed to you. For the money to be cashed to you. That's a negotiable instrument. At the moment when it was given to you, it wasn't money, but then it represents money. A promissory note at the moment it was given to you, it's not money, but it represents a promise to pay money. Okay. So I don't want to take too much time on the topic recap because we have plenty questions to go through. So insurance and banking contract, this is where individuals, contract has to do with individuals and financial institutions. So insurance companies, they take risk. So for example, you insure your car. The insurance company takes hold of that risk. So you enter into a contract that, okay, there's a risk that I may get into an accident, or there's a risk that my business place may catch fire. There's also and so the insurance company determines the likelihood of the risk based on their calculations, and they roll out for you the premium payment that you should make. The contract here is that as you are paying those premiums, should in case the risk occurs, it has been transferred to the insurance company. But the insurance company is the one who has to shoulder the risk and then pay and make sure that you are brought, they indemnify you, they bring you back to the state you were before that risk factor sets in. That's basically insurance. the insurance companies or the insurer has his or her rights. The one who is being insured also has his or her rights and obligations. As we try the questions, we'll be exposed to some of these things. Then we have contracts of employment, where we distinguish between uh, contract of employment and contract for employment, where one we say that one the person becomes a permanent employee, and the other one we say the person is doing his or her own work and is being contracted for his or her special services. That's contract for employment. And we have contract of employment. When we talk at employment law, it basically has to do with contract of employment, where an employer-employee relationship is going to be established. It begins with how employment is even established. What shows that a person has become an employee? That's where the issue of an appointment letter becomes very key, which states the dates of the appointment, which states the terms and conditions for the appointment. And a copy of such has to be given to the employee, and a copy is kept by the employer. We have the rights of the employee, we have the rights of the employer, and they all have their respective obligations as it relates to the law or the contract of employment, contracts of employment. Then we have the alternative forms and constitutions of business organization. That's where the law outlines the various recognized forms of business, the various recognized forms of business, where we have our sole proprietorship, we have our partnership, and then we have the main focus, which is the companies, and then how they are formed. We also have how they are formed. We have the various processes, we have the various procedures for the registration of all these companies. Like I earlier mentioned, the main focus, the one that has a lot of issues has to do with the company. Because when it comes to company, we have the certificate of incorporation. Before you get that certificate of incorporation, the various processes that you should go through. We have certain processes that should also go through there are certain individuals that should be present, or at least there should be two directors, there should be one owner when the company is being formed. Their details should be collected. There should be a book for owners. There should be a book for all shareholders, that's the owners or the members, and various regulations that come with that. Then we have the types of capital and financing of companies. Companies are financed in different ways. We have the share capital and we have the debt, whether they do so by issuing shares, or they raise their capital by going for loans. And going for loans, we have various ways of doing that. They can trade debt instruments, or they can go to financial institutions for loans. We have various rules and regulations that come with that. Over there, we'll see equity shareholders, we'll see preference shareholders, and all that. Then we have how companies are managed, administered, and regulated. That's where we see who are officers of the company. We see directors. We see the various types of directors. We see auditors. We see their role. We see company secretary. We see their role. These are officers of the company. They all have their obligations. They all have their rights. They all have their powers. They all have the scope within which they work. We have company meetings and resolutions. We see how companies are supposed to meet at least once annually. And we have instances where companies have to meet, which is beyond or out of the ordinary annual meetings. That's where we have the extraordinary meetings. We have rules and regulations that has to do with that. Who can call for an extraordinary general meeting? What instances can an extraordinary meeting be called for? Then we have resolution. What's a resolution? We know that resolution has to do with the decision making when it comes to companies. So companies' decision making process is what we call a resolution. So when they arrive at a decision, that's what we call a resolution. And usually this resolution is arrived at through voting. Through vote. The voting could be by raising of hands, can be by ballots, can be by polls, or however the company and the constitution decide that they do it. And we have what we call ordinary resolution, and we have special resolution. When we talk of ordinary resolution, that's where more than 50%. When we talk of special resolution. That's where 75% of the House or of the members present should support the issue. So there are certain issues that 50% plus vote is okay. There are certain issues that beyond the 50% plus vote, we need 75% plus to agree before those decisions can hold. There's a distinction between ordinary resolution and then a special resolution. I've spoken about auditing. Then we have instances where the next topic deals with instances where companies are in difficulty or companies are about to be dissolved. Companies are about to be dissolved. With that one, we are saying that there are various laws and regulations that come with it. There are instances where it is mandated by a court. They're looking at the way the company's finances are going. It's best that it is dissolved. The court can order it. We have the rules that come with that. Then we have a private liquidation. That's where the owners or members themselves determine that for one or two reasons, the company should be dissolved. That's a private liquidation. So they go into an agreement, and then the law also has provisions for that one. And the last area has to do with governance. When you talk of governance, we're looking at how companies are led, how companies are directed, how companies are led, how they are directed. So governance has to do with the main issue when we talk of governance. The main issue that we talk of governance has to do with the board of directors. That's the main issue that comes to play when we want to talk about governance. That's the main issue that comes to play. So the board, who can sit on the board? What's the constitution of the board? Those are the issues that come to play when we are dealing with issues of governance. That's the main issue that comes to play. Within the board, there should be committees. Within the board, there should be committees. All these are issues that comes to play. What are the various committees? What are their rules? What constitutes an effective board? Who are the type of people that should sit on the board? These are the main issues that come to play when we talk of governance or corporate governance for that matter. All right. Let me pause or let me cut the recap of the topic areas over here. Let me ask, are there any questions from all I've said or from what you've read? Are there any questions that we should address before we start going through our objective tutorials? Can we proceed, please?
Yes, please.
Okay. For the objectives, for us to make it interactive and for at least everyone to talk as much as possible. Oh, we're 9. Now we are 8. So I have 7 people on the call. Please, I hope we are not in noisy areas, so we can all talk.
Yes, please.
Okay. So this is how we are going to do it. For each question, one person will read, and then you attempt it, and then we discuss. One thing about objective is that beyond just answering the question, one objective question can expose us to other issues. The truth of the matter is that I'm not sure we can go through all the questions over here, but this document will be made available for you. I'm sure by the time you go through this document, and going through this document, I'm not what like I earlier on said, or I started my submission, which I started is that when you're doing objective type question, it's not about after reading question one, the answer is B or the answer is A, then you move on. No. Why is the answer A? That's what you should ask yourself. Why is the answer A? In trying to find out why the answer is A and the answer is not B, C, D, it will lead you to further issues because you are not likely to meet the exact same question. That when it comes, you can see that the answer is A. You may meet the same thing, but it will be asked in a different way, and the answer will be different. By delving deeper into the answer and the area which the answer covers, and it exposes you to different ways the question or different ways the question can be put. So that if it's put in a different way, the same thing, but if you put in a different way, which requires a different answer, you'll be able to answer it. So that's how we are going to go about it. Why is that people are leaving the call? Is it network? We were 9, then we went to 8, now we are 6. Okay, as they join, we'll continue. So, like I said, to make it interactive, we are going to be reading in turns so that you read, you attempt, we quickly discuss. The questions, like I started, we may not be able to go through all, but the documents we made available to you because these questions are a lot. It's 300 questions under each area. Some areas 40 questions, some areas 50 questions, some 35 questions. Under each area, we have a number of questions. We may not go through all. Maybe under each area, we'll pick 15 or 10, depending on the mark weighings of the area. So there are certain areas that, like, for example, the legal system. After we've done about the first 10, now let us move on to the next. So we may not go through all because there are a lot. We only have this first session and the evening session. And I know as we want, the way I want us to do it, it will take time because for each question, we want to understand why that is the answer. There are some questions that they are straightforward. That's the answer. There's no argument about it. But there are some too that we may have to scratch around it to see why that is the answer and give ourselves some more understanding. So like I said, should in case we see it in a different way, we'll be able to answer it. So at the moment we are 6. Okay. So Faustina, you will be, I'm assigning numbers, which is the order in which we'll be reading and attempting for a discussion. So Faustina, you are 1. Jan B, you are 2. Jan B, I hope you can hear me and you can talk.
I can hear you.
All right. Mohammed Dawda Rocky, please, you are number 3. Please, I hope you can hear me and you can talk.
Okay, so I'm here.
All right.
Yes, please.
Oti, you are number 4. You are the 4th person. I hope you can hear me and you can talk. Hello, Oti.
Yes, I can hear you.
All right. And then RKF. RKF. You are the number 5. I hope you can hear me and you can talk.
Yes, please.
All right. So in that the order I'll be doing it. So Faustina goes first, then Jan B, then Dauda, then Oti, then RF, RKF, RKF. As more people join, I would alterate the order. Okay, so let's begin. Faustina.
Question 1. The Supreme Court of Ghana decides a case on the interpretation of a constitutional provision. Which court is bound to follow that decision? It's C. All lower courts in Ghana.
They're all lower courts in Ghana. So the Supreme Court forms the highest. And we are saying that the Supreme Court is the only court. The question says decides a case on the interpretation. The Supreme Court is the only court that can interpret the law. So no matter the level of court, you don't say that I'm a district court, the next one above me, I'll go to the next court above me to interpret the law. No. No matter the level of court, no matter anywhere, even if it's outside the court, anywhere the constitution needs to be applied, and there's a need for the interpretation, that's the meaning of what the law is saying. It is only the Supreme Court that has the power to do so. All right, the next question. Please, as we attempt the questions, if anything is not clear, Please just draw our attention. Just draw our attention by saying you don't understand, and then we explain. Okay, let's move on.
Question 2. Amma commenced an action at the Supreme Court seeking damages for breach of contract by her employer. Which statement is correct? A. The Supreme Court has original jurisdiction in all civil matters. B. The Supreme Court may hear the matter only if the damages exceed 500,000 Ghana cedis. C. The Supreme Court has concurrent jurisdiction with the High Court in contract matters. D. The action is improperly commenced because breach of contract actions do not ordinarily fall within the original jurisdiction of the Supreme Court.
Please attempt it for us, and we discuss.
I think it's A. The Supreme Court has original jurisdiction in all civil matters.
The original court has. Okay. What are your thoughts?
I don't know whether I can say
think
something.
I
I
think
wanted
somebody
to say
was talking.
something. I wanted to say
Okay.
something to say.
All right.
I just want to seek permission that you pardon me small because actually I only joined the link and I've not yet studied, I've not yet registered, and I thought it was just a beginning lecture that you take us through. But then I've enjoyed what you have gone through. I'm actually planning for the last one, I think November or so.
Okay.
But I'm happy that you've taken your time to elaborate on the syllabus, and I just want to participate. So if
Okay.
I choose an answer that is very awkward, if I may say,
Oh,
pardon me.
we are all here to learn. Sure.
Uh,
That's fine. Sure. Okay. I think somebody was also sharing something. All right. So over here, the appropriate answer is D. The answer is D. Because for the A that you chose, Supreme Court has original jurisdiction in all civil matters. It's not true. Civil matters is the High Court. When you talk of civil matters, the High Court, like human rights, the High Court have different divisions. The High Court has different divisions where we have even the marriage and family aspects and all that. So when it comes to civil matters, it's not the Supreme Court doesn't have original jurisdiction. That statement is false. The answer will be D. The answer will be D, that the action is improperly commenced because breach of contract does not ordinarily fall within jurisdiction of the Supreme Court. You and two individuals, and when I say individuals, remember in the eyes of the law, the company is an individual. The company is a separate legal entity. So when I say two individuals, it could mean a company. So two individuals enter a contract and there's a breach. And the first point to follow up the case or to sue the case is the Supreme Court. That is improper. It's wrong. Just imagine you and your friend enter into a contract or start a business and enter into a contract on how the business will be run. Or you have a business and then there's somebody who supplies you and you enter into a contract and there's a breach and you go and send it to the Supreme Court of Ghana. You go all the way to the Supreme Court straight. It's not that it's wrong, but it's not appropriate. At least you send it to your district court. At least send it to your district court and you start from there. And even that one, the highest point that it should ordinarily reach to is the High Court. Is the High Court, not the Supreme Court. Because the Supreme Court, in a layman's view, the Supreme Court has very, very serious issues to handle, including the interpretation of law. So you bring in your case of a contract between two individuals is too simple, if I should put it that way, for the Supreme Court. There are lower courts that can address that issue. And remember, I'm not saying that an issue of law of contract cannot go to the Supreme Court. No. Look at what the option says. Do not ordinarily fall. So there could be instances where such issues can go to the Supreme Court. There could be instances after it has passed through all the lower courts, it is going higher and higher, even to the Court of Appeal, and it still seems that the issue is not being addressed, and the Supreme Court becomes the last option to go to. There are some issues too that are of national interest. It's a law of contract, all right, but you can't compare it to a contract between two people, like the example I gave. The Supreme Court may be the one to handle that issue. So it depends on the issue. So I'm not saying that law of contract issues cannot be sent to the Supreme Court. That's not what we are saying. So if you see a statement or an objective question that alludes to the fact that issues of contract or breach of contract cannot be addressed by the Supreme Court, it's a false statement. It can, but then it does not ordinarily fall within the jurisdiction of the Supreme Court. Let's proceed. Please, the pace we are going, is it okay? Are we all getting the understanding? Are we all getting the meanings and of why the answers are?
Yes, sir. Thank you very much.
All
Yes,
right.
please.
Okay, let's proceed.
Question 3. Which of the following best describe a persuasive precedent? A. Lesson that must be followed by all lower courts. A decision that must follow by all lower courts. B. A decision that may influence a court, but it is not binding on it. C. A decision on constitutional interpretation. And D. A decision automatically becomes law after 5 years. The answer is B.
Exactly, the answer is
And
B.
my reason is that a persuasive yes, please.
We are listening to your reason, please.
And my reason is that a persuasive precedent, you can present something that can influence the court. Maybe you have an evidence that can influence the court, but it cannot be, or it cannot serve as something that will be on the, like, what would I say? That will be binding on the court.
Exactly, that's true. So with the persuasive precedent, it can be, for example, one example is, for example, a case that was conducted, a similar case that was conducted, and a ruling was passed in maybe Nigeria or maybe in the UK. Okay, it's not something that happened in Ghana. It's different from if a similar case happened in the same court in Ghana and a ruling was made. That's usually the law, not even the law, usually in law, not that the law or a constitution, usually in law, it is advisable that the court remains consistent in its rulings. Not that it will give a ruling on this today and then tomorrow is giving something else in the same issue. So the law, the court is usually bound by the rulings it has earlier on passed. Says that when a similar issue comes, it has to give a ruling that is at least similar, so the law is consistent, so that the people who believe in the justice system do not say that for this person, the person did the same thing, the circumstances are similar, he was given 10 years imprisonment. This person also did the same thing, and he was given 2. Meanwhile, the circumstances are similar. The ruling should be. So that's where the court is bound. But persuasive, for example, where a similar issue happened, but it's outside the country, in a different jurisdiction, different circumstances, that one is persuasive. It can influence the decision, but it's not bound. The court is not bound that because a similar case happened in Nigeria and the person was given 15 years, we should also give the person 15 years in Ghana here. No, it's not bound. Or as our senior Muhammad said, he said that it could be that a certain evidence or a certain fact is presented. It's persuasive. It can influence the decision, but it doesn't form a basis. It doesn't form, you're not bound that because so and so happened like this, or because of so and so, the decision should be that. No, that case can be presented, it can affect the decision, but then the decision can even come out and it goes against that fact. So persuasive precedent, it means it can influence, but then it's not binding. It can influence. So anywhere you see something about persuasive precedent, what you should be looking out for is something that is influencing. It can influence, but it's not binding. For example, you have a friend who a friend who you like so much, you work with, you do your things together and all that. And now you have to make a decision about maybe a program you want to offer. And the person gives his or her opinion that, oh, looking at this, you should do A, B, C. Since the person is your close friend, his opinion can persuade you or influence your decision. By the end of the day, the final program you choose to go and read, it depends on you. You are not bound to follow what the friend has said because it's my friend and my friend said I should go and read this program. So I'm going to read this program. No, you're not bound. So when we talk of persuasive precedent, anywhere you see persuasive precedent in a question, you should bear in mind that persuasive precedent had to do with a precedent that is influencing a decision, but the court is not bound to follow it. The court is not bound to follow it. So you may be asked, which of these statements is true about persuasive precedents? A, B, C, D. You are looking for the one which suggests that the court, it can influence the court, but court is not bound by it. If you are asked, which of the following is not true about persuasive precedent? You are looking for the statement that is opposite to the fact that persuasive precedent influences, but it's not binding. Can we move on?
Yes, please.
Okay, please, who is next?
Okay, question 4. The doctrine of judicial president primarily promotes A. Judicial activism, B. Separation of powers, C. Consistency and certainty in the administration of justice, D. Parliamentary sovereignty, C. Consistency and certainty in the administration of
Okay,
justice.
even hinted on it already. That's where the when the a ruling or passes a decision, it becomes a judicial precedent to follow what it has already said. The example it has already said. So we'll believe in a justice system. I will not say that in scenario A, this is what the court chose. In scenario B, this is what the court chose. No. So it is for consistency and certainty in the administration of justice. So actually, in case the same issue comes up again, we can base from earlier decisions made by the court. And we know that this and this is how it first ruled. So now it should rule in a similar way to ensure fairness. All right, number 5.
Number 5. Which of the following is a source of law in Ghana? Which of the following is a source of law in Ghana? A. Professional codes only. B. Resolutions of political parties. C. Customary laws recognized by the Constitution. And D. Policies issued by private companies. So the answer is C. Customary laws recognized by the Constitution.
Okay. For this one, we know it's straightforward. We have the sources of law, and this is one of them. All right, question 6. So we are back to Faustina. Okay, Faustina, before you come, others have joined in. I think Felicia. Felicia, you're welcome. Please, I hope you can hear me and I hope you can talk. For those who just joined, as you can see, we are reading. To make it interactive, we read and attempt, then we discuss. We read, attempt, and discuss. So, Felicia, please, can you hear me?
Sir, this is Stephen. Oh, I just joined, but I would want to read.
All right. So, Stephen, you will be our number 6. So far, we're 5. So, now that you've done, you will be our number 6. So, you will take number 6. I don't know if Felicia. So, Felicia will be our
Okay.
number 7, but she can't hear us. Okay, so Senior Stephen, you will be our number 6. So you are 6th in the line. So you take the next
All
question
right,
from
sir.
us. Okay.
Okay, so number 6. The statute provides that no vehicles, bicycles, motorcycles, and other conveyances shall enter the park. Applying the ejusdem generis rule, the term other conveyances would most likely include A. Wheelchairs, B. Animals, C. Aeroplanes, D. Electric scooters. And I suggest the answer to be B. Animals.
B. Okay. Okay. Any other opinions?
Sir, I would have gone for D, electric scooters.
You'd have gone for D.
Yes, please.
Okay. Okay. Mr. Stephen, so why animals?
Okay, so I think that for animals like dog or domestic animals belongs to people. So if there is a ruling, we can factor the person in charge of the animal.
Okay. But over there it says other conveyance. No vehicles, bicycles, motorcycles, and other conveyance. And it's saying that applying the ejusdem generis rule, the term other conveyance will likely mean. So the emphasis is on the term other conveyances. Are you getting it?
Yes, sir.
So would you want to change your answer?
Yes, please. I'll go for the electric
No.
scooters.
Electric scooters. Okay. Raymond, you mentioned the electric scooters. Can you tell us why I said electric scooters? Maybe you can brief us on the ejusdem generis rule.
Yeah, so sir, with the ejusdem generis rule, I've forgotten the vivid, explanation to that. But what I can remember about it is that so when the law provides things like, let's say, vehicles, motorbikes, and then motorcycles, and at the end of the day, they said something like other conveyances. So what I used to identify, let's say, the other stuff would be, let's say, some of the features that these things possess. So vehicles, they move, like they convey people from one place to the other. Same applies to bicycles and the motorcycles. So electric scooters will also be something close, which conveys people from one location to the other. Yes.
Exactly. All right. All right. So to give some perspective to what you said, the ejusdem generis rule is a Latin legal term. It means of that kind or of that nature. So in interpreting the law, sometimes the law can list some examples of something. That list is not an exhaustive list. The law may not be able to list everything that falls in that category. So in order to make sure that the law is adequately applied or interpreted, the ejusdem generis rule is saying that the law may omit or may not give a full list of an issue it is trying to talk about. In that case, anything that is of that nature. So ejusdem generis rule means the literal meaning is of that kind or of that nature. So anything that is of that kind or of that nature of what the law is seeking to talk about will fall within that scope. So the law can say, or maybe there can be a rule at a certain place. There can be a rule at a certain place that, let's say, illegal substances such as weed, weed and cocaine are not allowed on the premises. You say, okay, they say weed and cocaine, so I will bring meth. Meth is also an illegal substance. I will bring meth. And when you are caught, you say, oh, they only mentioned weed and cocaine. The law will say no. What they said was illegal substances. So if they weren't able to list all illegal substances, and you have brought one that was not on the list, and you are saying that they didn't add it to the notice, so it's not part of the law, will say no. You can't take advantage of the law like that. The ejusdem generis will say that anything that falls within the category of the substances that is similar to the substances that is mentioned also falls within the category. So electric scooter wasn't mentioned, but electric scooter is a form of other conveyance. Wheelchair and aeroplane, they are also form of conveyance, but then they are not really close to. Remember, ejusdem generis rule means that or of that kind or of that nature. Looking at the list that was mentioned, bicycles, motorcycles, no vehicles, bicycles, motorcycles. What is closely, or what if we were to continue that list? So the law will say, ask yourself, if we were to continue the list, what are some of the things that could have been added? All those things are parts. So if you have to continue the list, we may not mention aeroplane because it is very rare that somebody will bring an aeroplane or be using an aeroplane from his house to work, or from his house to church, or from his house to. And wheelchair too does not necessarily follow this conveyance. Wheelchair is a medical consumable where somebody who can't walk uses it. So you can't say that no wheelchairs. No. Are we all clear on the ejusdem generis rule?
Yes, please.
So our answer is D. All right, let's proceed. I think another new person has joined. We have Enoch Apia and we have AC. Okay, Faustina, you start this round for us when we move all the way down to Mr. Steven. Then
Okay. Question 7. Parliament enacts legislation prohibiting the sale of certain medicines to minors. A court interprets the law by considering the social problem the legislation intended to address. Which rule of statutory interpretation has been applied? A. Literal rule. B. Golden rule. C. Mischief rule. D. 𝑭𝒍𝒐𝒖𝒓𝒊𝒔𝒉. Please, I can't pronounce. B. Golden rule. I choose golden rule.
golden rule. Okay, why golden rule?
What I know is the literal golden rule give a modification to the literal rule, and I don't really know much about that,
Okay.
but I go for golden rule.
Okay. In this case, the most appropriate is mischief rule. So, like you said, golden rule, literal rule means that we are taking the law as it is. Okay, the law as it is. This so and so is prohibited. as it is. Then the golden rule has to do with, like you said, it makes some modifications. It makes some modifications such that beyond what was said, what's the best thing that should be done? Okay, with regards to that law, what's the best that should be done? And the mischief rule looks at what the law intends to do, the intention behind the law. So by the answer of the mischief rule, and mischief rule because it's interpreting by considering the social problem the legislation intended to address. So it is trying to apply the law or interpret the law from the angle of the problem the legislation intended to address. So the legislation intended to address maybe minors having access to certain drugs. So it prohibits the sale of certain medicines to minors. So it's trying to address the situation of minors from having access to certain drugs, maybe because of their harmful effect. Okay. Now, if there's a situation where a minor is actually sick, okay, and he needs that drug, but here's the case, the parliament has brought out a legislation that certain minors shouldn't be sold to, a certain medicine, sorry, shouldn't be sold to minors. Certain medicine shouldn't be sold to minors. But here's the case that the minor needs the drug. Medically, he needs the drug. Prescription, he needs the drug. And now the law is saying that this medicine is prohibited from being sold to a minor. And here's the situation that the minor doesn't have anyone to go and purchase the drug for him, but it has been prescribed. He doesn't have anyone to purchase it for him. Per the circumstance, we are assuming hypothetically, he doesn't have anyone to go and purchase it for him, unless he himself walks to the pharmacy to go and purchase it. But he has evidence that has been prescribed for him, and it can be referred that it has been prescribed for him. In that case, the court, or if the matter is to be sent to court, the court will say that, okay, the reason why this law was put out was to make sure that minors don't have access to this drug to overdose it or to abuse it. That's the reason. So based on that reason, in this case, it's appropriate that you sell the drug to the minor. Why? Because in this case, he's going to use it for medical purpose, which has been prescribed to help with something he's going through or something he's suffering from. So in applying that law in this case, you will not be achieving the reason for which the law was put in place. Please, is it making sense?
Yes, please.
So if you want to look at the reason why the law was put in place, in interpreting or in applying it, you see that in that situation, you can't apply it strictly. Because in this case, it's not like he's going to overdose it. It's not like he's going to use it for his personal use. It's not like he's come to buy it for fun. So that's the mischief rule. The mischief rule will try and interpret the law from the angle of why the law was put in place. So that in the application, we'll be achieving that reason. Okay, let's move on. If it's clear, let's move on.
Oi. My screen.
Please, have you forgotten your numbers? Number
Question
2.
8.
The person after
Question
first thing, please. Okay.
Question 8. I'm muted. Okay. Question 8. A lower court refuses to follow a previous decision of the Supreme Court because it disagrees with the reasoning. Which statement is correct? A. The lower court is entitled to disregard the decision. B. The lower court must follow the decision notwithstanding its disagreement. C. The lower court may follow the decision only if the parties consent. And D, the lower court may disregard the decision if the matter involves commercial law. It's tough. But I'll go for B. The lower court must follow the decision notwithstanding its disagreement.
Okay, so like we earlier on mentioned from the beginning, we said when we saw something about I think in the question one, where the answer was when the Supreme Court interprets the law, all courts are supposed to follow.
Follow.
So the same way, the Supreme Court, as the word suggests, Supreme Court is the highest court of the land, the highest. So once the Supreme Court rules on something, no court can disagree with it. So it refuses to follow a previous decision of a Supreme Court because it disagrees with the reasoning. The lower courts or any lower courts cannot disagree with what they do because that's where the Chief Justice and other top justices are operating. So per their position, per their power, per their experience, once they pass a ruling, all others are supposed to follow it. So that decision to say that it will not follow what the Supreme Court has said, as you've rightly said, they must follow, notwithstanding their agreement. Because the one who interprets the law, the one who gives the meaning to the law, has given a decision. Who are you as a court to say you won't follow it? Okay, let's proceed.
Question 9. Kweku was convicted by a circuit court and wishes to appeal the decision. Which court ordinarily hears the appeal? A. District Court, B. Supreme Court, C. Court of Appeal, and D. High Court. I will choose D. High Court. And my reason is that District Court does not
Yes, we are
hear
listening.
appeal. I said D. I choose D.
Okay, the what? The what? Sorry, I think my network is. Please, can you hear me?
I said D. D.
You said D, the High Court.
Yes, please.
Okay, so convicted by a circuit court and wishes to appeal the decision, which court ordinarily hears the appeal. So why D? I believe you can hear me.
Yes, I can hear you.
Okay. So over here, I think the appropriate one should be Court of Appeal. Because ordinarily, you say which court ordinarily hears the appeals? Ordinarily, the Court of Appeal is a court that has appellate jurisdiction. Appellate jurisdiction, where an issue which is handled by lower courts and you are not okay with the ruling, you proceed to appeal the case to the Court of Appeal, as the name even suggests, Court of Appeal. Is it clear?
Yes,
Yes,
please.
sir. Wait,
Yeah, sir, please, I have a question.
Okay, Remo.
Yeah, so please, would it be wrong to, send the matter to the High Court, since the High Court is above the Circuit Court here?
No, it won't be wrong. It won't be wrong. That's why over here the word that was used is ordinarily, like ordinarily. So even when you send it to the High Court, they may even refer you to Court of Appeal, or maybe depending on the situation, they may handle it. Have I made sense? Do you get me?
Yes, please.
So they will now determine whether they will handle it or they will refer you. But ordinarily, it is the Court of Appeal that should handle that one. All right, let's proceed.
Okay, question 10. A statute provides that no person shall sleep in the railway station. A court finds that a person who lives permanently in the station and merely closed his eyes briefly did not breach the statute because a literal interpretation would produce an absurd result. Which rule of interpretation was applied? I'll go for mischief rule.
Okay, why mischief rule?
Like according to how you explained the previous question, the other question that you said it was mischief rule instead of golden, the one involving uh, a child, like giving him like unauthorized this one, a drug which was not accepted for this one. Yeah, so I applied that concept to.
Okay. So over here, you're saying that no person shall sleep at the railway station. So listen to the law. No one should sleep there. Now you're saying that somebody is living in the station and merely close his eyes briefly. He's living there and he just closed his eyes briefly, but he didn't sleep. He closed his eyes briefly, but didn't sleep there. But then he's living there. Did not breach the statute because of literal interpretation. He said did not breach statute because a literal interpretation will produce an absurd result. Which of the, you're saying, a court finds that a person who lives permanently in the station and merely closed his eyes did not close his eyes briefly, merely closed his eyes briefly, meaning he didn't sleep, he merely closed his eyes briefly, did not breach the statute because a literal interpretation will produce an absurd result. So the court has given its ruling, and he's saying that somebody who lives permanently in the station and merely closed his eyes did not breach the statute because, and the reason why he's saying the person didn't breach the statute is because a literal interpretation will produce an absurd result. Now, why the golden rule? Why golden rule? Why mischief rule? So we've earlier on said that mischief rule deals with the interpreting or the application of the law based on the reason for which the law was put in place. Based on the reason for which the law was put in place. Now, the golden rule modifies the literal rule. Both golden rule and mischief rule are modifying the literal rule. We've already said that literal rule means that you take the law as it is, you apply it raw. So what was I saying? Both the mischief rule and the golden rule are there to modify the literal rule. But the golden rule modifies the literal rule in order to avoid an absurd result. In order to avoid an absurd result. Meaning that if you are to literally or extremely or strictly apply the literal rule, literally apply the law, it may produce an absurd result. It may produce an unfair, extreme result. So the golden rule modifies the literal rule in order to avoid that absurd result. So from the question here, it said the court said the person did not breach the statute because the literal interpretation will produce an absurd result. So in order to avoid the absurd result, they are saying that this is how they are going to interpret the issue. So over here is the golden rule. I don't know if it's clear. So where the interpretation is done in a way to avoid an absurd result. When you say an absurd result, it means that the result of literally applying will be unusual or will be I'm trying to find the right word to use to replace absurd.
Unfavorable.
Yeah, unfavorable, unfair, abnormal. Okay, will be harsh, where we apply literally. So the golden rule is there to modify it so that where the direct or the direct or literal interpretation will produce an absurd result. That's where the golden rule comes in. So bear in mind, both golden rule and mischief rule, they are modifying the literal rule. But then the golden rule does it to where the literal interpretation will produce an absurd result. And the mischief rule interprets the law from the perspective of why the law was put in place. So over here, we are taking the golden rule because the question said the absurd result. So we are taking the golden rule. Okay. Question 11.
Yeah. Question 11. The Constitution of Ghana provides that customary law forms part of the laws of Ghana. Which of the following best describes customary law? The Constitution of Ghana provides that customary law forms part of the laws of Ghana. Which of the following best describes customary law? A. Rules enacted by Parliament and assented to by the President. B. Rules of law derived solely from judicial decisions. C. Rules of conduct developed from customs that are accepted as binding by a community. And D. Rules made by district assemblies for local administrations. The answer is C. Rules of conduct developed from customs that are accepted as binding by a community. Yeah.
Okay, that's for customary laws. Okay, so rules of conduct developed from customs that are accepted as binding by a community. Okay. But bear in mind that for customary laws, it is accepted so long as it is not contradicting with the constitution of the land. So an example of customary law, which may not be recognized as a law in the country, though a community can accept that it is binding, is the issue of maybe human sacrifice. So as a community, they can accept that human sacrifice is binding on us. Under so and so circumstances or under so and so occasion, a human being has to be sacrificed. Or if you give birth and so happens, the baby will have to be sacrificed. It's a custom that the community has accepted that is binding on them. But it is contradicting with the human rights laws that our constitution has put out. The right to life is contradicting with that. So in that case, that customary law will not be recognized as a law. So customary laws, what I want you to bear in mind is customary laws are sources of law to the extent that they don't affect human rights, to the extent that they don't go against the constitution that has been put in place. So we are going for C. We are going for C. Okay. Let's proceed. Who is next, please? I think that would be Senior Steven.
Okay, so number 12. Ōjó borrowed money from Yao and failed to repay the debt. You have commenced an action in the High Court. 𝒍𝒐 argues that the dispute should have first been referred to the Supreme Court because it involves a large amount of money. Which statement is correct? A. 𝒍𝒐 is correct because all high-value claims commence at the Supreme Court. B. 𝒍𝒐 is correct because the Supreme Court supervises all civil matters. C. 𝒍𝒐 is incorrect because the High Court has jurisdiction to determine ordinary civil disputes. D. 𝒍𝒐 is incorrect only if the amount involved is less than 1 million. I will choose C. 𝒍𝒐 is incorrect because the High Court has jurisdiction to determine ordinary civil disputes.
Okay. So the answer is C. Well, I'll urge you. I'm not really remembering. Trying to remember, I'm not remembering. I'll urge you to look into the D. 𝒍𝒐 is incorrect only if the amount involved is less than 1 million. You should look into the D and determine the various amounts. You know, every court, they have jurisdictions, and some of the jurisdiction has to do with amounts, where the case involves an amount of, is it 200, below 20,000, I'm not remembering. I don't want to say something I don't remember. So I'll urge you to look into that so that should in case you meet a question and the answer should be D because of the amount, you will know that the answer is D because of the amount. Because every court has some cutoff amount. They have cutoff amounts of cases that they can deal with from the district all the way up. So where you are asked the question and it may not even be about Supreme Court, it may not be about High Court, but then it's about a different court. And the answer has to do with amounts. Your knowledge of the thresholds is what will help you. So what I'm trying to draw your mind to is that in some situation, the answer would have been D, depending on the amount thresholds. Depending on the amount threshold. So you should look into that as you revise. Okay, so the new people who joined us, I think we'll add them to the queue now. Enoch appear, please. I hope you can hear me. Enoch appear. Enoch appear, I hope you can hear me. Okay, and Betty, you're welcome. I hope you can hear me.
Yes, please.
Okay, so we are adding you to our queue. So you are the next in line. So you are taking them. So you are after Senior Stephen. To make it interactive, we are all reading and attempting and we discuss. So you are next after Senior Stephen. So you are taking number 13. So you are number you will be our number 7. Yes. Senior Stephen is our number 6. So you will be our number 7. So after Stephen read, you are next to read. So we are taking question 13 for us. So read and attempt it and then we discuss.
Which of the following statements concerning
But if you can speak up a little, I don't know if I'm the only one who can really hear.
which of the following statements concerning the doctrine of separation of powers is correct? A. A parliament exercises judicial powers on behalf of the courts. B. One arm of government should not perform the essential functions of another arm. C. The executive has the power
to overturn final decisions of the Supreme Court. G. The judiciary is subordinate to the legislature.
These are terms for action.
Okay, I'll take B. One arm of government should not perform the essential functions of another arm.
That's separation of powers. So we are separating their powers, separating what they have to do. So one arm of government should not perform the essential function of the other arm. So we are separating what each arm of government should do or can do. So that's the separation of powers. All right, so we are back to the first thing. We are behind time, so let's try and speed up. Let's try and speed up things. I'd like if we can finish at
Okay.
least 2 areas before we end today. We are closing at 6:30. Okay, let's continue.
14. A decision of the Court of Appeal on a point of law will generally be binding on A. the Supreme Court only, B. the High Court and lower courts, C. Parliament and the Executive, D. all courts outside Ghana. I choose B. the High Courts and lower courts.
All right, so if you look at the hierarchy of the court, the appeal court comes over the high court and the lower court, such that all the lower court and the high court issues, as we earlier on saw in the question, if you are not okay with it, you send it to the Court of Appeal. The Court of Appeal, you appeal to them for them to relook at it. So the high court and the lower courts are the ones who are bound by that. All right, let's move on very quickly.
15. Parliament passes legislation imposing imprisonment on anyone who keeps dangerous animals in residential areas. A person keeps a venomous snake in his house and argues that a snake is not expressly mentioned in the act. Which rule of interpretation will most effectively defeat this argument? A. Golden rule. B. Literal rule. C. ejusdem generis rule. D. Mischief rule. I go for mischief rule.
Mischief rule.
Mischief rule because of the intention. Because the word dangerous means the snake is venomous, so it's also dangerous.
Exactly. So over here, you may be tempted to go for the ejusdem because the person argues that the snake is not expressly mentioned in the act. You may be tempted to go for ejusdem generis, but ejusdem generis comes when a list. So maybe so if, for example, the parliament passed the legislation and they mentioned examples, for example, lion, example, tiger, example, this, and then they didn't make a full list, and maybe snake wasn't on the list. That's where ejusdem generis will come in to say that any other thing that is closely as dangerous as those things on the list, that's where the ejusdem generis will come. But with this one, there was no list. The legislation just said dangerous. So the intention behind it is that you shouldn't keep dangerous animals. That's the reason for which it was mentioned was dangerous animals shouldn't be kept at home because it can cause harm to yourself and to people within a residential area. So the intention behind the dangerous suggests that snake is part. So D is our answer, mischief rule. Let's move on. Question 16.
Question 6.
Yeah,
Which of the following is not ordinarily regarded as a source of law in Ghana? A. the Constitution of the Republic of Ghana. B. Existing law and enacted legislation. C. Personal moral opinions of judges. And D. Rules of customary law. I will go for C because they say personal opinions.
Exactly. So if you look at the article of Section 10 of the Constitution, which states out the 19th Constitution, which states out the what is law and what are the sources of law. We see that Constitution is mentioned, existing law and enacted legislation is mentioned, use of customary law is mentioned. The odd one is personal moral opinions. And now bear in mind, he said not ordinarily regarded. Not ordinarily regarded. What the reason why he's saying not ordinarily regarded is saying that it's in a way personal moral opinions of judges are sources of law. In a way. Because at the end of the day, the person who is going to, the judge who is judging on the case, of course, his personal moral opinion of the case or on the issue, which is coming from the way he's applying the law, from the way he's interpreting the law, those, by all means, some personal insights also would play a role in arriving at the final sentence. You can't remove it from that. Yeah, they're supposed to be objective and all that. But as they are human beings, by all means, an aspect of their personal moral opinions will play a role. So that's why I said not ordinarily. So we are looking at the things that are mentioned as sources of law in the Constitution. Which one is not mentioned? And that's the personal moral opinion. Let's move on. Let's move on very quickly.
Okay.
Or has
Yeah.
OT left the call? I think OT has left the call.
Yeah.
Okay, so Raymond, continue for us.
Okay. Adwa loses a case in the High Court and appeals to the Court of Appeal. The Court of Appeal upholds the decision. She still believes there has been an error of law. Which court may hear a further appeal? A. District Court. B. Supreme Court. C. Circuit Court. D. Judicial Committee of the National House of Chiefs. So I'll go for B, the Supreme Court.
The Supreme Court, B is the Supreme Court. So beyond the Court of Appeal, there's no other higher court to the Supreme Court. All right. Number 18. Let's continue.
The rule of precedent is primarily based on the principle of A. Third decisive. B. Delegatis non potens delegate. C. Ras ipsa loquitur. D. Nemo dat scriu non habet. A. Third decisive.
Why is third decisive?
It stands by what has been decided.
Okay. So state decisis is a principle that it's obligates, or yes, that's the word. It obligates a court to follow decisions it has made in the past, like we already mentioned. So we said the rule of precedence is based on this principle that the court should be consistent in its decision, so long as a similar issue having similar circumstances is brought up. You shouldn't let anything change the decision that they earlier made. It should follow suit for consistency. All right. I think Betsy jumped, so let's go back to Senior Stephen. You should have read before Betsy, so read the next content. Number 19. I hope
Num
Senior Stephen. Okay.
number 19. Number 19. The statute provides that every trader selling food, beverages, fruits, vegetables, and other items shall obtain a license. Applying the ejusdem generis rule, the expression other items is most likely to refer to A. Buildings and land, B. Electronic appliances and vehicles, C. Other consumable products ordinarily sold by traders, and D. Shares and debentures. I suggest C. Other consumable products ordinarily sold by traders.
All right. So, like I earlier on said, the edges them is where there's a list. Where there's a list, then the list is not exhaustive. Okay. So, other consumable products ordinarily sold by traders. Okay. Let's proceed. So, we are back to you first. First, we are back to you. Okay, if it's not bad, it's not better you continue for us.
The Supreme Court departs from one of its previous decisions because it considers the earlier decision erroneous and unjust. This demonstrates that the Supreme Court A. is not absolutely bound by its own previous decisions, B. must always follow its previous decisions, C. can only depart from precedent with parliamentary approval, D. may overrule only decisions of foreign courts. It is not absolutely bound by its own previous decision.
You're choosing A.
Yes, please.
All right. So, the word making A the answer is absolutely. The word absolutely is what is making A the answer. Did we skip question 20?
Yes, we
I think we
did.
skipped it. Okay.
So I'll read that one.
Okay. So let's finish with 21. So the reason why A is the answer is because the word absolutely. Once you hear the word absolutely, absolutely means no matter the case, whether it is good or it is bad. Absolute means absolute. You take it like that. You take it the word absolute means you're taking it like that. So over here, per what we have seen, they say because the earlier decision is erroneous and unjust. And aside the Supreme Court, any other courts where the decision, they recognize that the decision was erroneous and was unjust, they are not bound to follow it. So the word absolutely is what is making A the answer. You can't say that because we are supposed to follow what we earlier on said, even when we recognize that it was wrong, we should still follow it. No. So the answer is A. Okay, question 20. Yeah, okay.
During proceedings before a high court, counsel relies on a decision of the Supreme Court of Nigeria because there's no Ghanaian authority on the issue. The Nigerian decision may be regarded as A binding precedent, B, an unconstitutional authority, C, a precedent that automatically overrides Ghanaian law, and D, a persuasive precedent. I go for persuasive precedent.
Exactly. So like we earlier on said, persuasive precedent, it can influence the decision. Go over here, we are saying that there is no Ghanaian authority on the issue. So since there's no Ghanaian authority on the issue, let's see how it was done in Nigeria. It can influence how we decide, but it doesn't form a basis. We are not bound by it. That because Nigeria ruled the case this way, which we should rule the case that way. That's persuasive precedent. All right, let's move on.
Question 22. Which of the following best describes delegated legislation? A. Laws enacted directly by Parliament through an act. B. Rules and regulations made by persons or bodies under powers conferred by an act of Parliament. C. Decisions delivered by the courts. D. Customary recognized by communities. I'll go for B. And my reason is that the laws enacted directly by Parliament through an act is not maybe given to someone, and then the decision also delivered by the court and maybe customs recognized by communities. But the B, they said rules and regulations made by persons or bodies under what? Conferred by an act of parliament. Maybe they have delegated the powers to another body or to make the rules and then the regulations. And that's my reason why I'm going for B.
All right, so if the question has asked best describes legislation, the answer will be A. Laws enacted directly by Parliament through an act. That will be the answer. But because it is delegated legislation, it means a law has been able to delegate, the Parliament has delegated someone else to make the law. So it's a delegated legislation. The legislation has been made by somebody who got power from the Parliament, but the person is not part of Parliament. The body is not part of Parliament. So if the delegated wasn't there, the answer would have been A, enacted by Parliament through an act. All right, so I'm seeing some activity in the chat box. Let me check. I'm attending to something. Okay, Steven said he's attending to something. You join soon. All right, let's proceed. Question 23.
23. A statute prohibits the keeping of dogs, cats, goats, and other animals in a hostel. The student argues that keeping a tiger is permissive because it is not specifically mentioned. Applying the mischief rule, the tiger should be regarded as A. Permissive because it is not expressly mentioned. B. Permissive only if the hostel regulations allow it. C. Prohibited because it falls within the mischief the statute seeks to prevent. And D. Prohibited only if it attacks another student. So the answer is C. Prohibited because it falls within the mischief the statute seeks to prevent.
Because the mischief the statute seeks to present, so the intention. Okay. Let's proceed. So maybe Betty, you can take it forward.
Please, I'm back.
Faustina is back. Okay. So
Yes, please.
okay, so Faustina, take it. Faustina, take it.
Okay. 24. Which of the following courts is principally vested with supervisory jurisdiction over all lower courts and adjudicating authorities? A. Circuit courts. B. Court of Appeal. C. District courts. D. High courts. So I think it's high courts.
Okay. So you're saying supervisory jurisdiction. Supervisory jurisdiction. If you were asked appellate jurisdiction, that would have been Court of Appeal. Supervisory jurisdiction. The Court of Appeal is higher than the High Court, all right. But the Court of Appeal is not the one to supervise. The Court of Appeal is there for when your issue is not, you feel the issue is not well handled, then you appeal to the appeal court for them to have a real look at it. The Court of Appeal is not the one in charge of supervising district court, circuit court, and even the high court. They don't go around supervise. They are there for appeal. But the high court is the one who is in charge of supervising these courts. Okay, let's proceed.
In 25, in the hierarchy of the courts in Ghana, which of the following is correct? A, Supreme Court, Court of Appeal, High Court, then lower court. B, Supreme Court, High Court, Court of Appeal, lower court. C, Court of Appeal, Supreme Court, High Court, lower court. D, High Court, Supreme Court, Court of Appeal, and lower court. I choose A, Supreme Court, then followed by Court of Appeal, then High Court and lower court.
For this one, I don't have to explain much.
Mm.
It's a rank. It's an order.
Okay.
So,
Sir, please, I have a question.
okay.
Yeah, so is appeal court the same as court of appeal? Or they are
Oh,
two
yeah,
different things?
it's the same. It's the same.
Okay.
They are the same. All
26.
right. Okay.
Kofi relies on a decision of the High Court in support of his case before another High Court judge. The earlier High Court decision is ordinarily A, binding on the second High Court judge, B, persuasive but not strictly binding on the second High Court judge, C, binding only if both cases involve commercial dispute, D, automatically binding if decided within the previous 5 years. I will go for B. Because when we mentioned about persuasive precedent, we said that it is binding, it is influential, but it is not binding on other.
Okay, so why Kofi is saying that the High Court, Kofi is saying that he brought a case to the High Court and a High Court judge made a certain decision. So now he has brought a similar case, or he has brought another case, and he is coming and saying that I brought this case to the High Court. It was Judge A that was sitting on it, and Judge A said so, so, and so. So Judge B, you two are supposed to say so, so, and so. And we are saying, or our brother Muhammad is saying that the answer is persuasive, but not strictly binding on the second High Court judge, and it's true. It's true. Though the judicial president, the court is supposed to follow suit with the decision it has made. Remember, we've put a clause on it. The absolute is not absolute. And two, depending on the extent to which the situation applies. And three, we saw a question where something about personal moral opinions also plays a role. So you can't go to a judge and tell the judge that Judge A said this, so you two are supposed to say this. No, the judge is not bound to follow exactly what the first judge who ruled on a similar case is supposed to do here. They are different people. They all have their ways of applying. They all have their training. They all have their experiences. They have their ways of applying. But essentially, as a court, as a high court, or as a court, they are supposed to follow they should be consistent with their decisions as much as possible. That's why other justices, if you look at the operation of the court, other justices should be also available when the decisions are being passed, so that the decision, there's some form of unity, or they join together. Sometimes there will be a jury that will all vote on the issue before the judge finally passes the decision. All these are put in place. But then you can't go to a judge and say that the reason for which the judge should rule a certain way is because another judge ruled that way. No. So that one is wrong. It's persuasive, but he's not bound by what his colleague has earlier on done. So the answer is B. Let's move on.
Question 7. Parliament passes legislation requiring every commercial vehicle to be insured. A judge interprets the law strictly according to the ordinary meaning of the words used in the text. Which rule of interpretation has been applied? A. Holding rule. B. Mischief rule. C. Pervasive rule. D. Literal rule. D. Literal rule.
Literal. So by the meaning of the words used, that's literal. That's literal. 28.
Which which of the following statements concerning the Constitution of Ghana is correct? A. It is subordinate to Act of Parliament. B. It derives its validity from customary law. C. It is the supreme law of Ghana, and inconsistent laws may be declared void. D. It applies only to constitutional disputes. And I choose C. It is the supreme law of Ghana, and inconsistent law may be declared void.
All right, this one doesn't need much explanation. Earlier on, I mentioned that even customary laws, they are seen as sources of law to the extent to which they don't contradict what a constitution has put down. All right, 29. Senior Jambi, I still with us on the call. I think you're next.
29.
Okay.
During proceedings, counsel cites a textbook written by a renowned legal scholar to support an argument. The textbook constitutes A. A delegated legislation, B. A source of binding precedent, C. Existing law, and D. A persuasive authority. I think it's D. A persuasive authority.
Persuasive. So it's not bound to follow what the textbook says, though the person is a renowned legal scholar. So it's just persuasive that according to this scholar, so and so and so. Not necessarily that because this scholar said this, so you're going to follow this. That's what the scholar said. And as long as it doesn't contradict what the law is also saying, we can take it. So it's persuasive, not binding.
Question 30. A company files an action in the Supreme Court seeking interpretation of a constitutional provision affecting its business operations. Which statement is correct? A. The action may properly be commenced at the Supreme Court because constitutional interpretation falls within its original jurisdiction. B. The action will first be commenced at the District Court. C. The action must first be determined by the Court of Appeal. And D. The action is incompleted because companies cannot invoke constitutional interpretation proceedings. And I choose A.
So actually, once your interpretation of constitutional provision, you know that it's a Supreme Court.
31. Parliament passes a law providing that no person shall operate a car, bus, lorry, or other motorized vehicle in a protected forest reserve. Kojo enters the reserve on a motorized tricycle and argues that the law does not mention tricycles. Applying the ejusdem generis rule, the answer is C, prohibited because it falls within the class of motorized vehicles contemplated by the statute.
So you say for ejusdem generis, once there's a list and something does not fall part of the list, but then it is in the nature of what's on the list. It is part of what's on the okay. This is Betsy. I think you take it.
Okay, question 36. The district court judge decides a matter in direct conflict with a previous decision of the Court of Appeal. Which statement is correct? The district court's decision prevails because it is the latest decision. B. The district court judge was required to follow the Court of Appeal decision. C. The district court judge may choose either decision. D. The district court judge was required to refer the matter to Parliament. B. The district court judge was required to follow the Court of Appeal decision.
Exactly. So this one too, we've already explained that. If the ones you are not explaining, if we get there and you still don't understand, please draw my attention. The reason why we are not explaining is because we've seen a similar thing already. So we can move fast. But if you do not get it, please draw attention. 33.
A company challenges a ministerial regulation on the ground that it exceeds the powers granted by the Enabling Act. The company is questioning the validity of A. Existing law, B. Customary law, C. Judicial law, D. Delegated legislation. I think it's delegated legislation.
Okay, so delegated legislation because it says a ministerial regulation. It means a ministry. In a ministry, they have put in a regulation. Remember, we said delegated legislation has to do with where a body which has received power from the parliament to make laws makes a law. So that law is also called delegated legislation. So now a ministry. Ministries are established or formed through an act. Okay, an act will give the ministry the power. An act will give the ministry the power to oversee issues when it comes to that sector or that ministry. Okay.
Thank you.
So since the act has given them the power to oversee issues, they've been delegated by parliament. They've been delegated by parliament. So any legislation they make becomes a delegated legislation. Becomes a delegated legislation. So for example, the Ministry of Finance, they have been mandated by the Public Financial Management Act, the PFM. They've been mandated by the Public Financial Management Act to oversee issues when it comes to public financial management. So now the act that was made by Parliament. So for that one, it is a legislation. It's not a delegated legislation. The PFM Act was made by Parliament themselves. So it is a legislation. And in that legislation, it gives power to Ministry of Finance. So now, based on that power, any regulation the Ministry of Finance makes becomes a delegated legislation. So a ministerial regulation. So a company challenges a ministerial regulation on the ground that it exceeds powers granted by the Enabling Act. So the Enabling Act becomes the Act of Parliament, which is the example I'm giving, the Public Financial Management Act, which gives power to Ministry of Finance. Now, based on that power, any ministerial regulation, any law that as a ministry they put in place becomes what we call a delegated legislation. So our answer is D, like you said. 34.
I don't know who is. Okay. A court 34. A court interprets a statutory provision according to the ordinary grammatical meaning of the words used, even though
So this
the
one,
result
even before you end, what will be the answer? You say
literally.
according to the ordinary grammatical meaning of the words used, even though
Yes.
the results appear inconvenient, the court is deciding to still go by the grammatical meaning. So that's literal rule. That's literal rule. So it's telling us that the various rules of interpretation, it is up to the court to apply which one they want to apply. So this is why I say, even though the results appear inconvenient, the court is still choosing to go by ordinary grammatical meaning. So that statement of even though the results appear inconvenient is there to trick you. It's there to trick you to go for golden rule. Because golden rule says that where the results will appear absurd, or over here there is the word inconvenient, you should modify the meaning of the literal rule and use golden rule. But over here, the question is saying that the court has chosen to go by the grammatical meaning, telling us that though it will appear inconvenient, they are choosing to go by the grammatical meaning. So the rule which has been applied is the literal rule. If they ask you the rule that should have been applied, what do we go for? What answer will we go for, please?
Golden rule.
Golden rule. Because the literal rule will appear inconvenient. So what should have been applied is golden rule. But the question is not asking you that. The question says, which rule has been applied? So our answer remains literal rule. Question 35.
𝒕𝒓𝒔𝒊𝒔𝒕𝒊𝒕𝒖𝒕𝒆.
35.
Abner relies on, okay.
Okay, 35. Where's my... Abner relies on a decision of the Supreme Court of Kenya before the High Court of Ghana in the absence of any Ghanaian authority on the issue. The Ghanaian court, A, must follow the Kenyan decision because both countries are common law jurisdictions. B, may consider the decision as well persuasive, but it is not bounded by it. C, must disregard the decision because foreign authorities are inadmissible. And D, is bound only if the decision was delivered unanimously. So I will go for B.
Okay. So this one is just like what you've already heard about persuasive precedent. So these are the few tutorial questions that we've done on the first part, which has to do with the legal system, in Ghana. So at least going through this, we've touched on issue of the courts, we've touched on issue of the precedents, we've touched on issues of the hierarchy of the courts, we've touched on issues of the interpretation. I think what we couldn't touch much on is the alternative dispute resolution. So by word of mouth, let me quickly recap that one. Alternative dispute resolution, as the name suggests, alternative. It means that an option, another way of resolving disputes, resolving issues, aside from going to the courthouse. That's alternative dispute resolution. So it's alternative dispute resolution. We are looking at, that's where we have, in fact, let me not do all the talking. Raymond, can you brief us? Alternative dispute resolution. I've already introduced it, and I've introduced why we do alternative dispute resolution, that we are looking for other ways than going to the court, because the courts will take time, the courts will take money, the courts may end up in grievances and all that. So one may feel cheated or something. It may affect business relationships that are already existing at the end of the court proceedings. So there's alternative dispute resolution. And even you can go to the court and ask the court to do alternative dispute resolution. That's where you will not go by, you bring your lawyer, I bring my lawyer, we fight on what the law says, and then we end that the law will give a ruling, or the court will give a ruling. No. You can go to the court and do alternative dispute resolution in the court. That means the court will put aside its normal way of doing proceedings based on the parties, the two parties that have the case will tell the court that, though we are coming to the court, let us do this not along with how the court will usually deal with issues, where each of us has to bring a lawyer. But let us do it in a different way. So we have negotiation, we have reconciliation, we have arbitration, and others. So Raymond, quickly walk us through the types. Quickly walk us through the types.
Oh, okay. So yeah, so as said earlier, ADR is other options aside the traditional, way of settling disputes. And some of the methods involved include arbitration, where we give the case to an independent and an impartial person known as the arbitrate, arbitrator, yes, known as the arbitrator. So over here, he renders a decision that is binding on the parties. So the independent and impartial person, after hearing the case, renders a decision that is binding on the parties. Then the next is mediation. So mediation also involves an impartial person or a third party who also hears the matter. And what the mediator does is that he tries to help the parties reach a mutual agreement. So the decisions that he makes are not binding on the parties, involved.
That's for which one?
Yeah, that mediation.
Okay.
Yes. And then we also have conciliation. So with the conciliation, what I remember is that the conciliator, yes, plays an active role, and his or her purpose is to settle the dispute, and also the decisions are not binding unless both parties agrees to make it binding. So unlike the arbitration where the arbitrator makes a decision that is binding, the conciliator, what he does is that the decision, he makes sure that the parties involved agree to it, that every decision that is being made are binding on them. So he gives the room to the parties to make sure that the decisions are binding on them. Then we also have negotiation. Negotiation simply talks about bargaining. Yes, so that you get the parties involved to talk things through, and then by the end of the day try to settle it by themselves. Yeah, so basically that's what I remember about ADR. Yeah,
All right.
the
All right.
method.
So there's one type which is med up. Med up. Med up. That's the only one I think you've omitted. Where it starts with mediation, but when the mediation is not working, it proceeds to arbitration. So we said with mediation, they are trying to resolve it through a third party. So the third party will help them. The reason for mediation, and even this one can come as a question, where so we don't just use any ADR or any alternative dispute resolution. You don't just pick any for nothing. And I'm using mediation to explain this. You pick mediation where the issue is that maybe they are not understanding themselves. So maybe party A and party B. Party A has a different perspective of the issue. Party B has a different perspective of the issue. Meanwhile, it's the same issue. So party A will talk to the mediator. Let the mediator understand what he understands. Party B will also do same. Now the mediator will now talk to party B that, okay, this is how party A views it. This is his understanding. And then vice versa. Then party B will now see that, oh, okay, so this is what party A is trying to communicate. This is understanding. This is his view. Party A will also understand that, oh, okay, this is what party B is trying to communicate. This is his view. This is understanding. And then based on that, they now understand themselves well, because since the two of them are having an issue, it is possible that because they are blinded by their emotions, they are blinded by what they seek to achieve, they are not actually calming down to understand the point from which each other is coming. That's what the mediator does. So you can be given a question. So that's the reason for using a mediator. So a question where the issue is that they are not understanding themselves. It's like they both have opposing views, and they are not actually taking time to understand each other, which form of ADR should best work over there? The answer should be mediation. That's where a mediator is needed. The mediator now becomes like a channel through which they communicate, and he's able to let each other understand the other. So that in that case, mediation or a mediator is the most appropriate form of alternative dispute resolution. So with the med app, it starts with the mediation. But where the mediation is not working, then it becomes arbitration, where the person who was before a mediator will now become an arbitrator, and he will give a final verdict on the issue, and it becomes binding, as Raymond has suggested. So you can be given an issue where the alternative dispute resolution began as a mediation, but the mediation doesn't seem to be working. Which alternative dispute resolution should be the next form that should be resorted to? The answer is the med app, or mediation arbitration, where it started with a mediation, then it becomes an arbitration. So you should bear in mind the types and why, the forms and then the why. Okay, so maybe you can be asked, people want to sort out an issue through a third party, but they do not have in mind that the third party should give a final decision. Mediation can come in, or the third party will give suggestions. The third party will give suggestions, but then it's not binding. The suggestions are not binding. That one becomes a conciliation. Conciliation. Okay. So you should understand their forms and then know when they should be used. So that when is you are brought, because there are various alternative dispute resolution forms. So I'm just letting you know the angle from which questions can come, because this is objective type test. You're not going to be asked to define or so what you should know is the instances which is best or which is most appropriate for a type of alternative dispute resolution. So that brings us to the end of the first aspects of the syllabus. The first aspect of the syllabus. All right, so we are coming to the legal rules. We have a few minutes ahead of us. Let's see if we can do a few questions under this. This is the area that has a lot of issues. The legal rules relating to loss of obligation. That's where we have contract. That's where we have agency. That's where we have torts. That's where we have torts. And that's where we even have the insurance and banking, this one. So that's where there are a lot of issues. So even in our tutorial set, that's the one that has the most questions, because it cuts across a number of issues. So we are looking at legal rule. That's even where we have sale of goods, hire purchase, and I think even negotiable instruments. So legal rules we get really relating to law of obligations. That's the where matters arising cause or bring up obligations. For example, a contract, for example, agency relationship, for example, sale of goods. All right, let's proceed. Let's see if we can. At least we have about 5 minutes.
Okay.
Raymond, do you want to ask a question?
No, sir. I'm reading.
Okay.
Okay. Kweku wrote to Ama on Monday offering to sell his laptop for 8,000 Ghana cedis and stated that the offer will remain open until Friday. On Wednesday, Ama posted a letter accepting the offer. On Thursday, Kweku attempted to revoke the offer. Which statement is correct? A. The contract was formed on Friday when Ama's letter was received. B. The contract was formed when Ama posted the acceptance letter. C. The contract was formed only after Kweku acknowledged the acceptance. And D. No contract was formed because Kweku revoked the offer. And so because of the postal rule, I'll go for B, option B. Yeah.
Okay, option B. So when Ama posted the acceptance letter, the contract was formed. So postal rule is something that came as a result, even though it doesn't really apply strictly here because these days, hardly will we write letters or hardly will we form contracts by writing letters. But back in the day, the postal rule was there because maybe somebody would accept an offer, write the acceptance to the offer, but it will take time for that acceptance to reach the person who made the offer. So within that time, a lot of things can happen. The letter can be lost. The letter can be damaged. Some delays can come in. But then to protect the person who has already accepted the offer, we are saying that the day, and of course, the post office will have records. The day that that letter was posted, the contract has been formed. So that if maybe after that day, maybe the acceptance delayed, then the person who made the offer trying to cancel the offer, the person who has already accepted the offer and has even maybe started acting, maybe the person accepted has maybe even started acting, but the letter of acceptance is yet to reach the one who made the offer. To protect that person, postal rule is saying that the day that the letter was posted is the day that the contract has been formed because acceptance was posted in a letter. That's the postal rule. That's a short that's a short summary of the postal rule. Question 2.
Question 2. Which of the following is an essential element of a valid contract? A. Writing. B. Registration. Agreement supported by consideration and presence of a witness. I think it's C. Agreement supported by consideration.
There's an agreement supported by consideration. So you form an agreement and then each person is bringing something on board. C. All right, question 3. I think you spot our order. Faustina, are you there? Or Betty?
Ada promised to give Kojo 10,000 dollars as a birthday gift. Before the money was delivered, Ada changed her mind. Kojo said, which statement is correct? Kojo will succeed because every promise is enforceable. Kojo will succeed because the promise was made voluntarily. Kojo will succeed if he genuinely accepted the gift. Kojo is unlikely to succeed because there was no consideration. Kojo is unlikely to succeed because there was no consideration.
Exactly. Because this one is a gift. It was just a promise to give a gift. Kojo didn't do anything to earn it. So he hasn't brought any consideration to earn that 10,000. So you can't say that based on the promise. No. The only instance in which Kojo may succeed is where the doctrine of estoppel will come in, saying that based on that promise, Kojo has gone to incur some liability or he has gone to do something. He has relied on that promise and it's now coming to a disadvantage. That's where the doctrine of estoppel will stop Ajwa to pay that money because Kojo has relied on the promise. But in this case, where that is not the issue, he is unlikely to succeed because he has not done anything to earn that money. It was just a promise. It doesn't form a contract. Remember in the just past question, we said contract is what? Agreement supported by consideration. He didn't bring any consideration, so he can't sue. Our time is up. Let's do question 4 and 5, and then we know that we reach legal obligation. Question 4 and question 5. All right, let's do question 4 and 5, please.
Question
Question
4.
4.
Okay, Mohammed, read.
Question 4. Which of the following generally amounts to an invitation to trade rather than an offer? A. A signed agreement to sell land. B. A written promise accepted by the offeree. C. Display of goods in a supermarket with price tags. And D. A bid accepted at an auction. Is C. a display of goods in a supermarket with price tags.
Okay, please attempt to ask. You said the answer is what?
I said B. I said C.
B.
C.
C. Okay.
C.
Okay. Invitation to trade. Yes. So that's question 4. C. Display of goods in a supermarket with price tag. So it's just inviting you to come and buy. Just inviting you to come and buy. All right. Question 5. Question. John B. End for us. Question 5. The last question for today. For this month. So.
Question 5. Yao offered to sell his vehicle to Mensa for 70,000 Ghana cedis. Mensa replied, I will buy it for 65,000 Ghana cedis. Before further discussions, Mensa attempted to accept the original price. Which statement is correct? Mensa's early response amounted to a counter offer and terminated the original offer. B. Mensa may accept because the original offer automatically remains open. C. Mensa's response merely requested information. And D. A contract exists because the parties intended to negotiate.
Oh, there's a little technical. It's a little technical. Betsy, please help John Beagle. This is law of contract.
No. Mensa's earlier response amounted to a counter offer and terminated the original offer.
So you are choosing A.
Yes, please.
All right. So with this one, in law of contract, we said in this case, Yao offered to sell his car 70,000. So we said when I was doing the overview, I said law of contract begins with an offer. So this is an offer. So he offered that he will sell his car for 70,000. Who did he make the offer to? He made the offer to Mensa. It's now up to Mensa to accept the offer or not. Now Mensa said, I will buy for 65,000. By saying that I will buy for 65,000, per our answer, by Mensa saying that I will buy for 65,000, he has cancelled the first offer and he has made a new offer. So in this case, the table has turned. First, Yao was the one making the offer for Mensa to accept. Mensa is now making another offer, which we call a counter offer. So now the table has turned. Mensa is now making an offer of 65,000 and it's now up to Yao to accept or not. So before a final contract will be made, the offer and acceptance can turn about 5 times. This one will make an offer. The next person will counter the offer. And when he counters the offer, it means he's making a new offer. It's now up to the other person to accept. The other person can also make another offer. In that case, the table has turned again. He is now making an offer. It's up to the other party to accept. So at the end of the day, until final acceptance is made, the offer keeps getting cancelled and a new offer comes on the table. And that's what happens when we go to the market to buy. The seller quotes the price, you also quote the price. So you cancel this offer, you made a new offer. He cancels your offer, he makes a new offer. Back and forth like that. That's counter offer. So each time a counter offer comes on the table, the original offer is cancelled. And it's up to the other party to accept the counter offer or also put another counter offer. That's what we are seeing in question 5 over here. All right, our time is past. We'll end here. We'll meet in the evening at 6:30 p.m. to continue. As you can see, we've not reached anywhere. This is page 8 of 60. We have about 300 questions to go through, and I think we've done about 40. So I think when we come back in the evening, I'll allocate time. So for each of the remaining areas, we'll divide it by the number of In the evening, we have to do about 3-4 hours per the timetable. We'll divide it by the time or the hours so that for each section, maybe if it's 30 minutes per section, no matter the time no matter the number of questions we reach after 30 minutes, we'll stop and go to the next section. If there's time, we come back. The answers are there, so I'll share the answers so that even if we are not able to tick all the answers on the document, you have the answer. There's a separate document with all the answers, which you can use for your revision. All right. If there are no questions, we'll end here. But I hope we have been able to revise. We have been able to learn. Okay, in the comment section, yeah, in the chat box. Yeah. Oh, thank you, Janbi. Thank you. Alice, your first time hearing some things. I'm happy, Alice, you understand this club. And I hope when you are going to write, by the time you are going to write, everything will be very clear. But thanks for still joining. Okay, so if there are no further questions, I think we'll end it here. So we'll meet in the evening. Have a nice day. Let's join on time in the evening so that we can cover as much